Hello and thanks for joining us on Chicago Tonight. I'm Brandis Friedman. Here's what we're looking at. The Supreme Court is back in session. On the agenda, LGBTQ rights and presidential power. Local court watchers weigh in.
I would like to be remembered as a compassionate person.
And funeral arrangements are announced for Loyola's beloved Sister Jean. First off tonight, from the Velvet Hammer to federal inmate 90368-509, former history-making Illinois House Speaker Michael Madigan is off to prison. The Chicago Tribune reports that the 83-year-old arrived at the low-security federal prison in Morgantown, West Virginia today to begin serving his 7.5-year prison sentence. A jury convicted Madigan of numerous corruption charges, 10 in all, relating to bribery schemes and his efforts to secure a valuable state board position for disgraced former Chicago Alderman Danny Solis. Earlier this month, an Illinois appellate court rejected his request to remain free while he appeals his convictions. In another effort to curb the disruptions to her community, Broadview Mayor Katrina Thompson is shrinking the designated protest area outside the suburb's ICE facility. This means protest demonstrations will only be allowed outside the facility on Beach Street in Broadview, not around the corner on South 25th Avenue. Thompson says Saturday night protests led to 15 arrests. Meanwhile, elected officials, including Illinois House Speaker Emanuel Chris Welch, are calling on immigration officials to remove the fence constructed nearby on Beach Street.
For several weeks now, without permission or collaboration with this community, this fence you see behind us has been standing here blocking the community's access to its own streets and standing as a symbol of division. It's a symbol of Donald Trump's contempt for this community and so many like it.
And Welch represents the 7th District where Broadview is. Last week, a federal judge ordered the federal government to remove the 8-foot fence, finding that it likely exceeded its statutory authority when erecting the fence, and that the fence prevents the village from protecting the health, safety, and welfare of the public. Chicago's Cardinal Blaise Cupich is pushing for faith leaders to be allowed to visit immigrants in ICE detention facilities. In a speech today at the Union League Club of Chicago, Cupich cited the role the church serves in ministering in Cook County Jail. In the panel discussion, Cupich also took questions on the Catholic Church's role in politics.
The church should have a voice in the political sphere. We shouldn't have a voice in the partisan sphere. There's a difference between politics and partisanship.
More than half of municipalities across Illinois are adopting a 1% grocery sales tax. It'll replace revenue lost when a statewide grocery tax expires in January. The Illinois Municipal League, which tracks which cities and villages adopted an ordinance, says 656 municipalities will begin collecting the tax on January 1. Chicago did not meet the October 1st deadline to implement a grocery sales tax by the beginning of the year. The league says without the revenue, public safety, utilities, and infrastructure maintenance and repair could be affected. A Northwestern University professor has received the Nobel Prize in economics for his work in explaining innovation-driven economic growth, along with 2 other researchers. The Nobel Committee says economics and history professor Joel Mokyr used historical sources as one means to uncover the causes of sustained economic growth becoming the new normal. Those 3 prerequisites for growth include useful knowledge, mechanical competence, and institutions conducive to technological progress. This afternoon, Mokyr said he was surprised by the announcement this morning, but has spent his life studying the history of economics, even those systems that no longer exist, to understand how technology advances and changes. Up next, we look at a busy Supreme Court term that could have big consequences right after this.
Chicago Tonight is made possible in part by the Alexandra and John Nichols family, the Jin and Kay Mabey family, the Polk Brothers Foundation, and the support of these donors.
The Supreme Court's new term just kicked off. On the agenda, free speech, LGBTQ rights, tariffs, and broad executive power, just to name a few. The justices are set to hear 39 cases on the court's regular docket, and they've already sifted through almost 30 Trump-related cases on the so-called shadow docket. Joining us to talk about all of that and more are Carolyn Shapiro, law professor and co-director of the Institute on the Supreme Court of the United States at Chicago-Kent College of Law. She served as a clerk to Supreme Court Justice Stephen Breyer. David Franklin, associate professor of law at DePaul University. Franklin was a clerk to Justice Ruth Bader Ginsburg. And John Giocaris, attorney at the law firm Rock, Fusco & Connolly. He is also a member of the Federalist Society. Thanks to all three of you for joining us. Okay, so starting with birthright citizenship, because I think the Trump administration's position on immigration is no more apparent than it is right now. And this issue of birthright citizenship, though, it's not on the court's docket just yet, but President Trump, we did know, signed that executive order back in the beginning of this year, which seeks to deny citizenship to people who were born in the U.S. to non-citizen parents. And of course, this raises questions about the scope of the 14th Amendment. John, start at the beginning, please. Not too much at the beginning, but
Sure.
Why was the 14th Amendment created?
So the 14th Amendment was predominantly created to protect children of ex-slaves, to protect their rights, make sure that that slavery, the institution of slavery wasn't passed on to them. And what challengers of the interpretation of birthright citizenship to the 14th Amendment have alleged is, while it was intended to protect specifically that class of people, and while there has been a Supreme Court precedent in 1898, Kim Wong Ark, that held that children of permanent legal residents are entitled to birthright citizenship, the court has never actually ruled on whether or not birthright citizenship applies to children of non-legal aliens. And so what proponents of President Trump's executive order is trying to do is basically shove this in front of the court, and President Trump has certainly been very aggressive with his executive action. He's actually had more executive orders than any other president since Franklin Roosevelt. They want to get an interpretation of birthright citizenship as it applies to children of non-resident aliens.
How will this issue eventually make it before the court for a final decision?
So it already had sort of a preview before the court last term when they were deciding on the constitutionality of nationwide injunctions at the district court level. The Trump administration has asked the court to revisit this case again. It's quite possible it could get on this on the docket this term. In any case, it's going to get there at some point, whether it's now or later.
Can I just say, Brandis, this issue, I think, is an example of a broader phenomenon, which is that the Trump administration is pushing the envelope in ways that are blatantly unlawful, right? So the executive order on birthright citizenship is inconsistent with the text of the 14th Amendment, the history of the 14th Amendment, English common law before the 14th Amendment, the Supreme Court's decision from the 19th century, and congressional legislation. Lower courts have uniformly said it's blatantly unconstitutional to deny citizenship to people who were born here just because their parents happen to not have immigration status. So there isn't even really a split between the lower courts that would normally necessitate Supreme Court review. But what we've seen the court do again and again on its so-called emergency or shadow docket is sort of short-circuit the normal orderly process of appellate review and basically tell the lower courts you're not allowed to enjoin these initiatives by the Trump administration because in the Supreme Court's view, those lower court decisions somehow create irreparable harm to the administration. I don't know if we'll see that in the birthright citizenship context. I think the court, by saying no nationwide injunctions last year, was trying to kind of push that issue off and kick the can down the road. But on a whole host of other issues, including issues that implicate what I think of as the Trump administration's authoritarian agenda, the court has been content to allow those policies to go into effect.
And I definitely want to come back to the shadow docket in just a second. Carolyn, there is precedent here, U.S. versus Wong Kim Ark. How strong is that, and could the current court realistically either overturn it or narrow it?
Well, immigration was different then, just the whole body of law surrounding immigration. So the circumstances of that case are just hard to map on, but it involved a child of Chinese immigrants who couldn't become citizens, but he was born here and he was deemed to be, the Supreme Court said, yes, absolutely, the 14th Amendment means that he is a citizen. The executive order that the president signed doesn't just reach the children of undocumented immigrants. It also reaches the children of immigrants or people who are here, but legally
with legal status,
but not permanently. So, or not necessarily permanently. So, people here on student visas, people here on H2B visas who are working legally, people here on tourist visas. There's never, so it's not limited. The order is not limited to undocumented immigrants.
Which could have sweeping impacts,
Yes.
of course. What would that mean then for who gets to be an American?
It would have sweeping impact, and we don't know what the administration, how the administration would apply that retroactively. They've said, well, it won't apply the actual order to the executive branch, which is, don't issue passports, don't issue Social Security cards. That, they say, is going to be forward-looking. But then if they get this interpretation of the 14th Amendment, which I completely agree with David, is not remotely plausible, but if they were to win that argument, then what would happen to all kinds of people who have always thought they were citizens because they always have been citizens?
Okay, so we've mentioned the shadow docket. Let's get into it. The Supreme Court's, so-called emergency docket, shadow docket, being used in record numbers in Trump's second term, and he's also winning more cases than his predecessors. David, do we know why there's such an increase in these emergency applications?
Well, we'd know more if the Supreme Court wrote opinions that accompanied these shadow docket rulings. More often than not, they don't. So these are situations where a lower court has put a stop to some administration policy. And in case after case, I think it's 23 in a row now, the Trump administration has gone to the Supreme Court, has jumped the queue, and has said, we want emergency relief. We want you to tell the lower courts to lift those temporary injunctions. That's all they are. The lower courts are saying, we think this policy by the Trump administration is unlawful, and therefore, during the pendency of litigation, we want to put a stop to it. And the Supreme Court, apparently, based on a few things that it has deigned to tell us, seems to think that those kinds of lower court rulings create irreparable harm for the government, that the government being told, you're doing something new, and the lower court has said, let's put a pause to it for now, that lower court ruling creates irreparable damage to the government. And so the court has lifted some 23 in a row of those lower court rulings. And in those
instances, like you said, there's only been a few instances where the court has actually written an opinion. I guess, to the non-legal person, I'm like, well, kind of, how can they make decisions without having had formal hearings and without issuing necessarily a formal opinion on that?
Well,
it is
they
within their purview.
They have the power to do it, and they're doing it.
Okay.
And I think, just real quick, I think another reason why they've had to rely more and more on the emergency docket is because, as I said, this Trump administration has been very aggressive on executive action. Again, more executive orders than any other administration since the Roosevelt administration. Go ahead.
Carolyn, is this something we should be concerned about?
It's absolutely something we should be concerned about. What the court is doing is allowing the administration to change the facts on the ground in situations where we don't have an adjudication about whether or not something is in fact legal or constitutional, and changing the facts on the ground in a way that it's not possible to put things back together. That's the point of these preliminary injunctions that the lower courts are issuing, is that you hold off. Things are supposed to be, the litigation is supposed to be relatively expeditious, but the standard that the Supreme Court is supposed to apply requires not only that they be able to say that the president or the administration would likely prevail, but also that there is this irreparable harm. And they simply have not explained that beyond in the first birthright citizenship case, which was only about the nationwide injunction. There's real a real suggestion that any time the Trump administration is told no, it's automatically irreparable harm.
Okay, so I want to get to some of the cases that actually are on the real live Supreme Court docket. There is the one of Trump versus Slaughter. So the court is also re-examining a 90-year-old precedent that prevents presidents from firing heads of independent federal agencies like the Federal Trade Commission without cause. Trump's legal team argues that those restrictions violate the Constitution's vesting of executive power. So in September, Supreme Court did allow Trump to fire Rebecca Slaughter temporarily. John, why is Trump set on ousting Slaughter?
So this goes to what proponents of the Trump administration believe is unitary executive theory, which is that under the president's Article 2 executive authority, he can fire pretty much anyone from any administrative agency at will. Again, not to keep coming back to the Roosevelt administration, but the precedent on this 90 years ago was Humphrey's executor, in which case the court held then that President Roosevelt could only fire someone from an independent agency for cause, not simply at will. And many conservative, libertarian constitutionalists have always held that the court erred in that decision. It might have been the result of a very hostile court to the Roosevelt administration that thought he was overstepping his authority. So ever since then, we've had this precedent, but there are many scholars across the board who actually think that this precedent is probably on its way out. And the fact that the court is allowing Commissioner Slaughter to be dismissed until this is fully adjudicated is probably a sign that it is on its way out.
Similarly, though, Trump is also trying to remove Lisa Cook, who serves on the Federal Reserve Board of Governors. Supreme Court will hear arguments on this in January, David. What interest would the court have in keeping an agency like the Federal Reserve independent, and what would be the legal basis for that?
Well, first, I agree with John that the arguments that are being made in these cases on behalf of the Trump administration are kind of a culmination of a generation-long movement within the conservative legal establishment to establish this notion that the president has to have hierarchical control over everything that happens within the executive branch. And I think the Supreme Court pretty clearly has signaled that it agrees with that theory. Interestingly enough, the biggest proponent of that theory was the late Justice Antonin Scalia, who was an originalist. So he believed that the Constitution should be interpreted according to its original meaning. I think the originalist case for a unitary executive theory is pretty questionable. And in fact, we've just seen today a prominent originalist scholar at the University of Virginia saying, I don't think that there is a strong originalist case for the unitary executive. But I think clearly in the FTC case, that's the case of Ms. Slaughter, the court is going to overrule that 90-year-old unanimous opinion of the Supreme Court. But you're right, the court seems to think that the Federal Reserve is different. So in one of its shadow docket rulings, it wrote a couple of sentences saying the Federal Reserve has a unique history. I don't know that logically that really holds up, but I know this. The Supreme Court has gotten a brief from every living former Fed chair, Republican and Democrat, telling the court that in countries that have independent central banks where the president comes in and removes that independence, what do you get? You get runaway inflation and you get economic crisis. You know, just ask anyone from Argentina. We don't want to become the next Argentina.
Okay, so let's see if we can get through a few more of these before we run out of time. Childs versus Salazar. So few cases dealing with LGBTQ rights. This is one of them. The case centers on Colorado law banning licensed therapists from practicing so-called conversion therapy on minors, citing research showing that the practice can be harmful and even, in double the risk of suicide. A Christian therapist named Kaylee Childs suing, arguing that the ban violates her First Amendment right to free speech. Carolyn, why is this case framed as an issue of free speech versus medical regulation?
Well, that's exactly what the argument is in the case. The state of Colorado says, look, we regulate medical practice all the time. That often includes the regulation of speech. That's all that's happening here, and that's how it should be understood, which means it would be evaluated on a relatively deferential, quite deferential standard. Ms. Childs says, no, this is coarse, this is my speech. Colorado is telling me what I can and can't say, what my beliefs are, and so it should be, they need to have an extremely high justification. There are some very strange things about this case. One is she's actually said she doesn't want to practice conversion therapy. And the state of Colorado says they are not going to enforce this law against her. So one might wonder what this case is doing in the Supreme Court at all. But it is comparable to a case called 303 Creative versus Lannis that was decided a couple years ago, also out of Colorado, involving a web designer who didn't want to be told she had to serve
build websites,
wedding websites for same-sex couples. She won her case on, again, hypothetical case, because she didn't actually wasn't making wedding websites, but she won it on a free speech basis.
Okay, quickly, the court's also expected to weigh in on major cases involving transgender athletes, Little versus Hecox and West Virginia versus BPJ. John, conservative experts argue this is about maintaining fairness in competition, not about discrimination. In 30 seconds, how do you think the court is going to approach that argument? So
there was a case last term, Scrimetti, which pertained to whether or not states could constitutionally ban gender-affirming care, and the court upheld that right. In this case, we're talking about whether or not states can ban athletes who are assigned a specific gender at birth from participating in women's sports. Since we're talking about sex discrimination, this will hinge on intermediate scrutiny. Basically, it's going to boil down to whether or not gender identity falls within Title IX in women's sports. Title IX, which of course protects against sex discrimination in sports. Indeed. Real quick, you think what? Do I think there's a majority on the court that might affirm the law at issue? Yes. Yes. Okay. Thank you. Good job. We'll have to leave it there. I'm sure there's more to discuss as the term goes on. Carolyn Shapiro, David Franklin, and John Giocchiaris. Thanks, everybody. Thank you.
Thank you.
Up next, remembering Loyola icon, Sister Jean. Funeral arrangements are being announced today for Loyola University Chicago's beloved Sister Jean. She was a fixture on the university's campus for decades, working directly with students and serving in many roles, including chaplain of the men's basketball team. While just about every Rambler over the decades knew or knew of Sister Jean, she became an overnight sensation across the country back in 2018 when Loyola's men's basketball team made its historic Final Four run. We sat down with her a couple of years ago and asked her what that popularity was like for her.
It was very exciting, and after we won the first bracket, I woke up the next morning in the hotel room and I said to myself, "Ooh, this is not a dream, it's for real. Get going, girl." So I thought to myself, I should, because two people from our communications department came and said, "Sister Jean, there are some reporters want to talk to you." And I said, "Oh, you better come with me." So they came with me, and I was all mic'd up, and the reporters kept following me for each game. They kept coming to the locker room because they told me to go there to talk to the young men and so forth. And I always smile when Tex put one microphone in my pocket. One time I had 5 microphones in my pocket, and I had a whole host of reporters around me. And that was before the game, and they were asking me what I was going to say in my prayer with the team before. And so I told them, and then I told them I would always give a scouting report. And so they said to me, "Oh, are you going to tell us?" And I said, "No way." And then afterward, one reporter came to me and she said, "Do you think you could tell me, Sister Jean?" And I said, "No, you might be a friend of the opponents, and I don't want them to know what we're going to do." But I just had so much fun.
But
really,
how would you like to be remembered?
I would like to be remembered as a compassionate person, one who really wants to relate to people, help people, and to remember me as someone who really loves God, loves them, loves what I do. And sometimes people ask me, well, do you really love what you do? Oh, yes, I do. When I wake up in the morning, after I thank God for bringing me to the day and asking Him to help me serve Him the rest of the day, I think of what I'm going to do that day. So that's where my purpose comes in, that I'm thinking of my own plans. Sometimes the plans don't go to fruition, but then you just readjust and do something else and do the plan the next day.
And the wake for Sister Jean will take place on Wednesday at 5 p.m. with visitation from 5:30 to 10 at the school's Rogers Park campus. The funeral is set for Thursday at 10. Seating will be open to the public on a first-come, first-served basis. Services will also be live streamed, and we have more details on our website. And that's our show for this Monday night. Join us tomorrow night at 5:30 and 10. Now, for all of us here at Chicago Tonight, I'm Brandis Friedman. Thank you for watching. Stay healthy and safe, and have a good night.
Closed captioning is made possible by Robert A. Clifford and Clifford Law Offices, a personal injury law firm that gives back to the community through law and philanthropy.